Chairman. I thank you for holding this hearing on this important topic, the administration's detainee policy and its plan for reforming the Military Commissions Act of 2006. Let me begin by welcoming our witnesses, the Honorable Jay Johnson, General Counsel for the Department of Defense, and the Honorable David Criss, Assistant Attorney General, Department of Justice. Gentlemen, good morning. Thank you for being here. On October 22, 2009, the President stood before the American people and announced that he would uphold his political promise to close Gitmo within a year and suspend all military commissions pending a review by the administration. I do not want to make this a political issue. I think if Senator McKeon had been elected, he probably would have done the same thing. Let me say that at the outset. Additionally, the President announced the creation of a detainee task force that would review America's current terrorist detention policies and practices and recommended a path forward within 6 months. Mr. Chairman, many in Congress were skeptical of this approach. It seemed unwise to have a policy to close Gitmo without a plan. We immediately pointed to the danger of establishing a definite date to close Gitmo without first having identified an alternative location to detain these dangerous terrorists. Additionally, we warned that a policy vacuum from the executive branch would be filled by unelected judges who are not accountable to the American people. Our ultimate concern was that our military personnel serving in Iraq and Afghanistan could be vulnerable because of a lack of specific guidance from the Commander-in-Chief. I had the opportunity Monday with 3 of my colleagues to go to Gitmo, and it was quite an education. And I have a solid view of what I think should be done there now, and probably different from what I would have thought a week ago. But as we were flying back from Gitmo, we received notice that the administration would not meet the President's self-imposed 6-month deadline for meeting the President's new detention policy. This delay is disturbing on many levels and deserves the attention of the American people. On one hand, I commend the President for the delay. On the other hand, it puts the trials, the things that we're working on down there, in suspension that I think cause some real problems. So we're kind of between a rock and a hard place on this. Earlier this year, I joined with many in Congress to support legislation which would have required the President to notify a state governor and legislature 60 days prior to the transfer or release of a Gitmo detainee into their state. Number 2, obtain the consent of the state governor and legislature to the transfer or release. And 3, certify that the transfer or release of a Gitmo detainee would not adversely affect the national security of the United States or residents of the United States. Similar language was adopted by this committee in the House NDAA. In other words, Congress has made a bipartisan statement that it cannot fund any policy until it receives a plan. Given the 6-month extension for the detainee policy task force and the President's self-imposed deadline to close Gitmo by January 2010, I'm concerned Congress will be handed a predetermined outcome, and this would be an unacceptable outcome. Given the vacuum of information surrounding the administration's detainee policy, today's testimony takes on even greater importance. Let me briefly lay out my views on the issues I expect our witnesses should cover today. Mr. Chairman, a comprehensive detention policy must include a strengthened authority to detain and a preventive detention framework. A plan for detaining high-value detainees captured outside Iraq and Afghanistan where they will not have habeas corpus review. A plan that ensures federal courts do not release detainees from Gitmo into the United States. And a clear framework that does not favor prosecuting detainees in federal criminal courts, but prosecutes violations of the laws of war in military commissions. A commission system that protects sensitive sources and methods and is tailored for the exigencies of the battlefield. And finally, a plan that ensures that detainees we transfer or release from U.S. custody do not return to the battlefield and threaten our forces or citizens. It's the issue of transfer and release that gives me pause. When I visited Gitmo on Monday, one of our briefers showed us a picture of a former detainee that was released because he was compliant and seemed to no longer pose a threat. The picture showed him holding a child. It turned out we were wrong. He later blew himself up and killed 25 people in Baghdad. We've been wrong, according to DIA, 14% of the time. I fear we're getting it wrong in Iraq and Afghanistan, too. Just this week, the New York Times reported that detainees released from American prisons in Iraq could have been the ones that carried out an attack on a restaurant, wounding scores of people. Every time we get it wrong, the consequences are fatal. We need to be honest about the risk of releasing detainees into Iraq, Afghanistan, and especially the United States. I look forward to your testimony, and I hope that the discussion we have today will give this Congress and the American people a better understanding of the President's detainee policy. Thank you, and I yield back.